Good morning. Happy Saturday, part two. I've had some questions about what Earl's talking about in this video, so I figured we'd go through it. I do have the speed turned up. You know what? We could do 1.75. Hopefully, we can get through this real quick. I don't want to spend forever on it. So let's dive into it and let's see how much bullshit Earl's spewing.
Oh, okay. I'm going to give it a minute for some people to get in here so I can cover all this mess.
Cover it, right.
Yo, Psycho Cowboy fan.
I have not watched this, by the way. So
JR,
I have no idea what I'm
Alamo Eyes, Seth Sethman. Let's get a few more. Get a few more in here. Hey, Dan, how you doing? Oh, there's a lot of gossip. So, let me see what we got here. We'll get one more in here. Oh, we got more than one more in here. All right. So I'm going to jump into this. Hey, sweet Reef, tweet. You know what I'm talking to. So I had court yesterday, and the purpose of court yesterday was to determine who got the jury. So for those of you that don't know, here in Harris County, due to COVID, we're like 4,000 criminal trials behind. I mean, it's ridiculous. Hey, Kathy Franklin.
That sucks. Justice delayed is justice denied. If you don't have enough courts or juries to get these criminal matters through, then you should do something. The state should do something. The county should do something. Somebody should do something to get these criminal matters taken care of. And it's not just for the defendants in these. I mean, the victims need justice too. And you're like, oh, you're a defense attorney, you shouldn't say that. Well, you know what? Sometimes there are actually victims. Sometimes there are actually victims, and those victims deserve justice just as much as defendants deserve justice. So, don't give me that. I'm also a plaintiff's attorney, and if those victims want to sue those defendants and they're just waiting on the criminal trial to wrap up, then, justice delayed is justice denied.
So this is on the case out of Deer Park that involves my daughter. And so we had one guy ahead of us and for getting the jury, and they weren't ready for trial, so we got the jury. The judge called the district attorney and my attorney up to the bench for a conference, and she basically told the DA, she's like, how did y'all even file this case? What are y'all doing? I can't believe you're actually going to take this in front of a jury. It's a loser case. Why are we wasting?
So that right there, what he just said there is a lie. I can tell you that's a lie because the judge, number one, hasn't seen the evidence. That's problem number one. The judge hasn't seen the evidence. The evidence is presented at court in trial. That's when the evidence is presented. Trial has not happened. Judge has not seen the evidence. So the judge is not in a position to know that it's a loser case. And if the judge, for whatever reason, is in a position to know that it's a loser case, like if Earl had filed a motion to dismiss and the state's allegations were insufficient to maintain a cause of action, then the judge would grant the motion to dismiss. Or if the judge thinks that it's a loser case, the judge can sua sponte, issue an order to show cause why this judge shouldn't dismiss the case. And the judge has not done that. The judge, there are 4,000, by Earl's own admission, there's some 4,000 cases behind on the criminal side of things. And the judge says this is a loser case, but I'm going to allow this to go ahead and waste time that could be devoted to cases that have merit. Does any of this make sense? I suggest to you that it does not. This man is lying to you right now.
In the court's time, blah, blah, blah. Anyway, DA made some excuses. Now, for those of you that don't know, in Texas, the judge can't dismiss the case. Only the district attorney can.
A judge can't dismiss the case? A judge can't... A judge can't dismiss the case? Are you effing kidding me? Judges in Texas don't have the power to control their own dockets. They don't have the power to dismiss cases that they have found are a waste of time. Okay. So let me just run this through you. Let's say that in Texas, a defendant files a motion to dismiss, and the DA says, "No, I'm not going to dismiss the case." and then the judge makes a ruling on that motion to dismiss in favor of the defendant. What happens to the case at that point, Earl? What happens to the case at that point? Does the case get dismissed based on what the judge says? Or does the case not get dismissed because the prosecutor said no? Holy Jesus Christ. And, you know, if the judge actually thinks, if the judge, there was a thing yesterday. What was it? But if the judge actually thinks that there's no merit to the case, then the judge can issue an order to show cause that the judge can issue an order to show cause as to why the case shouldn't be dismissed, which is basically like the judge forcing a motion for dismissal and putting the burden of proof on the DA at that point to, you know, show that there's probable cause to continue with the case. But you know, the weird thing is that the DA offered a dismissal. So the judge can't dismiss it, and the DA offered a dismissal, and the DA can dismiss it. Only the DA can dismiss the case. So, you know, like, does any of this make sense to anybody? Like, how do people believe this bullshit?
So I have two lawyers on this case. And one of them was out yesterday sick. He's got COVID. He took the test, and I went with my lawyer back to his office. And while we're there, he gets a call from the other lawyer, and, you know, he lets him know, hey, I've got COVID. All right, well, he signed on to my case, which means we've got to let the court know. So my primary lawyer calls the court and says, hey, the secondary lawyer, the co-counsel, has COVID and will not be attending jury selection. So we're supposed to do jury selection this morning. Will not be attending jury selection. But we are ready for trial, and we want to go ahead. We're going to move forward. The district attorney found out that my co-counsel was out sick. In Texas, if a lawyer is signed on to the case, he must appear for trial. Even if he's just co-counsel, he must appear. So the district attorney took it upon herself to go to the court clerk and reset the case again.
So in Earl's world, only the DA can dismiss a case, but the defense can refuse to allow the DA to dismiss a case. The judge can't dismiss a case, and the DA can unilaterally reset court appearances. Okay. Like, you know, I can imagine that if, it seems weird to me, but I can imagine that if there are two attorneys representing, there'd be a lead attorney and a co-counsel. If there are two attorneys representing the defendant, then there may be some sort of a rule that both attorneys have to be present at jury selection. There may be some sort of rule about that. And if that is the case, I can imagine that once Earl's attorney let the DA know, the DA might have informed the court as well as Earl's, you know, not an ex parte communication, but they might have submitted some sort of a declaration or something to the clerk stating that dude's out for COVID, and the clerk might have had it reset through the court, through the judge. The clerk would probably have reset. Yeah, so I can see something like that happen, but the DA does not have the power to unilaterally reset hearings. If in fact there is a rule that requires both attorneys to be present, if you have two attorneys representing you as a defendant, and if in fact one of the attorneys was not able to appear for jury selection the next day, then yeah, I'm assuming that Earl's attorney, his primary attorney, would have had a obligation to notify the court as well. So I'm assuming that both attorneys notified it. So yeah, none of it makes sense.
Initially, they set it off till the 15th of September, and then they changed that yesterday to the 29th of September. And we're coming up on 4 fucking years that these people have been keeping me from working, keeping me from traveling where necessary. They let me travel a little bit, but right now they're not letting me travel at all.
Yeah, you know, there's this whole thing, you know, you have a right to a speedy trial. And somebody, I'm not going to mention any names, but it's probably Earl, waived his right to a speedy trial. So whose fault is it, Earl? Maybe there's a reason why you have that right to a speedy trial, and maybe there's a reason why you don't waive it. And once you do waive it, then you start blaming everything because, oh, it's been forever and ever. What about all the continuances that your attorneys asked for, Earl? What about those? We're just going to ignore those? Those aren't your fault, Earl? You're taking no responsibility for your own actions in all of this? And now that the court is backed up with 4,000 criminal cases because of COVID, now all of a sudden, now the whole 4 years is the court's fault. That's what we're going with.
I want to go to Uvalde, and the judge said absolutely not. So basically I live off my savings, and think about the average person. How much money do you have in your bank account? How long could you live off of that money?
You live off your savings, Earl? I thought you made hundreds of thousands of dollars a year making YouTube videos. But now it's off your savings?
I'm very fortunate. I don't have a lot of bills. Everything I own. And, and I had a substantial amount of money in the bank. And I've made some good investments over time, and that has, proven to been good for me. But what I'm getting at...
Oh, he has money in the bank, which means he's not judgment-proof at this point. Nice. Be careful, Earl. If you do have money in the bank... So one of the big problems with suing people, especially people with no money, is that you get a judgment, and then that judgment basically is worth about as much as a roll of toilet paper is, because it's just a piece of paper. And I have said before that some people are judgment proof. Like if you don't own land, if you don't have any income, if you don't have any savings, you're judgment proof. And if you do own land, like in California, all I can do as an attorney, if I want to collect a judgment, I can record an abstract of judgment in the county that you have your land in, and then I get paid if you ever sell that land. Or I could attach a lien on the property, theoretically. I could garnish your wages if you have any coming in, but that's limited. If you make less than, if you take home less than something like $15 an hour times 40 hours a week. So if you take home less than $600 a week, $600 or less a week, then a wage garnishment isn't going to attach anything. It's anything in excess of that, I think, that you can garnish. If I remember correctly, it's been a while since I looked at it. And even that, you're limited to the amount you could take. I think if it's for child support, it can go up to 50%, I think. And if it's for not child support, I think you can go up to a third. But yeah, it's super limited. Bank accounts, you can levy bank accounts. Well, I guess technically the sheriff can, but you submit your sheriff's instructions and everything to the sheriff to levy bank accounts if you know somebody has money in the bank. And if they don't get the money out of the bank in time, then the bank will take that money and send it to the sheriff, and the sheriff will take their little bit of it and send the rest to you. And yeah. So anyway, judgment proof. If he actually has money in the bank, he's not judgment proof. There was a time when I considered suing him, and I had someone look into it, and if I remember correctly, the land that he's on, that his trailer's on, I think it belonged to his son or something like that. I don't remember exactly the details of it, but basically, they couldn't find anything in this dude's name that had any value attached to it at all. So, or was it a wife or a girlfriend's name? I don't remember. It was somebody else's name, that the land that was his, in air quotes. So I didn't end up suing him. He said, he's basically called me a pedophile, which, it's kind of a weird thing. A guy who's actually been arrested for the sexual assault on his own daughter is accusing me with no criminal record of being a pedophile. But anyway, that's not here nor there. We've been recording for a long time. We've only gotten 5 minutes into this.
Hey, Cass. You duck plucker. I see you, Cass. But, the average person, how long can you... First off, if you were arrested for a crime you didn't commit, you had to post bond. Could you afford to do that? Could you then afford to hire a lawyer to fight the case? This is beyond...
Well, first of all, you don't necessarily have to post bond. There's a lot of times, like if you own land or something in the area, there's a lot of times you can get out on OR, own recognizance. They basically have to look to see if you're a flight risk, yada yada, and the minimum that it would take to secure you to that particular area. And if you own land, there's a pretty good chance you can get out on own recognizance, like if you own property. And as far as like hiring an attorney, there is public defender options available if you don't have enough money to do that. So yeah, now I'm not saying that there's no penalty associated with being arrested. I mean, you're going to lose money. I mean, you're going to spend a day or so in jail. You're going to have to take time off work to make your court appearances. I mean, there are going to be costs involved, and that sucks. And I mean, it would be great if someone could come up with a way to do all of this without costing defendants money until such a time that they're actually convicted. But unfortunately, we don't have a system that does that. So, it sucks, but that's the way it is.
Egregious, you are correct. Anyway, the answer to that is the average person would be cash strapped. Like I said, I'm very fortunate. And when you look at the emails from Deer Park, they make it very clear that they thought I was broke and would be sitting in jail and have to use a public defender and would end up having to take some kind of deal, some kind of plea bargain. And basically I would get screwed. And so what I'm thinking about is all the...
I also don't understand how he thinks that Deer Park controls all of this. Because Deer Park is a refinery that was part owned by Shell and part owned by some Mexican, the Mexican state oil business, because Mexico's the nation Mexico, the state of Mexico owns its own oil companies. So I don't understand where he's going with on this, but okay.
People that can't afford to hire a lawyer, can't afford to make bond, that's what's happening to them, and that's our justice system now. That's our criminal justice system now.
It's not really a justice system; it's a legal system. There's no. You get very little justice out of our legal system. I will. People think that I'm like a big fan of this legal system. It's the best we've got, and unless you have a better system that you can actually say how a better system would work, then I don't know what to say. Like, criticizing it, great. It has its defects, but it's not really helpful unless you could actually say something that would make the system work better. And I've seen a lot of people try to do things that they think will make it work better, like no cash bail. So either if they let you out, it has to be on basically own recognizance. You don't have to pay any money for bail or bond. And that hasn't worked out so well in the places they've tried it. And yeah, I mean, but it's cool that they're giving it a whirl. They're trying new things, but all I'm saying is unless you can actually come up with a better solution, then it doesn't really make a lot of sense to complain about it. Yes, it sucks. Yes, it's broken. It's completely not perfect, but it's the best we've got right now. So, we've got to deal with it as it is because it's reality. And, please do come up with a better solution. I would be all in favor of it.
It's wrong. We're going to have to change it. And,
yeah. Okay. So give us your alternative there, oh sage wise man.
Shell Refinery's been bought out. Lied to his teeth. I believe it, Truth Seeker. I absolutely believe it. But anyway, getting back to what was going on. So they reset the case to the 29th of September. That's when we picked the jury. And then the actual trial will begin. 4 years this has been going on. So what I'm going to encourage you to do, they don't need to set it off that long. The co-counsel that's got COVID will be over it in a week, 10 days, 20 days. If they had just set this off till the first part of August or something like that, I'd be okay with that. Not a big deal. But
well, there's 4,000 cases, right? He said there's 4,000 cases. There's a backlog of 4,000 criminal cases. So the court already has other people scheduled in. Just like Earl had a court date set for July 13th. Other cases have set dates at this point. And so I am sure that when they first picked 9/15, they thought they had a slot available to get another trial in on 9/15. They found they couldn't. Then they had to set it again to 9/29. I think it's 9/29. I forget. Doesn't really matter. Anyway, there's 4,000, by your own admission, there are 4,000 other cases backlogged, Earl. You're not special.
2.5 months more? And keep in mind that as we approach this date for court yesterday, the district attorney is saying, oh, hey, we need to reset till August because I'm not ready for trial. 3.5, 4 years this thing has been going on.
The DA doesn't just say that. The DA would file some sort of a motion to do that. The DA would file some sort of a motion. And you know what? The DA did not do that. The DA instead issued subpoenas. I wonder if I can do this without showing you my my login information. Well, you didn't get to see my password. That's all that matters. So we're going to go to criminal. We're going to go to warden. And we're going to go to search and see if my terrible internet will allow me to search. And this is Earl Warden. And here's the docket sheet. And we're going to make that a little bit bigger. So it hasn't been 4 years, I guess. I guess the complaint was filed in 2019. Huh. It's been 3.5 years there, Earl. I know, I'm nitpicking now. So let's see. I don't see a motion to continue it. I don't see a motion to continue it. And then we have witnesses. Look at all these subpoenas. So from right here up, these are all that they've resubmitted. So that, you know, the DA and everything have submitted these. These were all the ones that were previously. These were for the 7/29 hearing, I believe, down to there. And you'll notice that like this K.N. Devers. She was done multiple times, wasn't she? There's Krausen, and she was done multiple times. Krausen, so like they've had their witnesses for a while. There's Krausen. So I don't necessarily think that the DA is not ready to go to trial. I really don't think that. One other thing I wanted to show you, because in here I believe it shows things like reset upon defense request, reset upon defense request, reset upon defense request. Here's one reset on prosecutor's request. But there's 1, 2, 3, 4, 5, 6, 7, just on this one page, 7 resets by defense request, 7 of them, and 1 by the prosecution. 1 by the prosecution. And that was back in 2019 for something about CPS records. It wasn't for a jury trial. It was for something else. So, I mean, whose fault is it, Earl? Whose fault is it again?
And they're not ready for trial. If you're not ready for
who's not ready for trial? I mean, I don't think anybody's not ready for trial, Earl.
Trial after 3.5 years, you're not going to be ready for trial. They know I'm innocent.
If they knew you were innocent, then they wouldn't be prosecuting you, Earl.
They have the evidence. They absolutely know I'm innocent. And in the state of Texas, under the Morton Act, they are required, if they know I'm innocent or believe me to be innocent, to drop the charges. They're not doing.
Well, yeah, so they're required to, and they're not doing it. We have two options here. We have to believe that either they don't think you're innocent, or they're violating the law. They're risking their livelihoods to violate the law. I don't know which is more probable, Earl. Is it more probable that you're lying or that they're lying?
Doing it because they are trying to silence me, trying to keep me quiet.
If they were trying to silence you, then what are they doing like right now? What are they doing right now? Have they taken any action to eliminate your YouTube channels, Earl? Like, how are they trying to silence you? And why is your daughter trying to silence you, Earl? Because remember, your daughter is the complainant in this case. She's the victim. She's the one who's saying, I was assaulted sexually by my father, by Earl David Worden. What about her, Earl? Is she bought off by Shell? Is she a cop? Is she trying to silence you? Is she somehow upset at your First Amendment activities, Earl? None of this makes sense. There's this giant conspiracy theory that each little piece, he tries to make it sound like it makes sense, but when you put all the pieces together, the puzzle doesn't work.
And say, well, yeah, but you're just an auditor. I was the most effective auditor out there up until this happened.
By what metric? By what metric were you the most effective auditor? Because I would hazard a guess that Philip Turner was probably the most effective auditor for quite some time. I mean, there's actual case law because he spent his own money to hire an attorney to press through up until he got a Fifth Circuit Court of Appeals decision. He spent his own money to get that. You might not like Philip Turner. I don't think Philip Turner understands Turner v. Driver, the decision, and the limitations that are on it. Like the fact that there can be reasonable time, place, and manner restrictions on your right to film the police and what that means. So I don't think Philip Turner understands Turner v. Driver, but he got it. He paid his own money to get it. He paid a lot of money to get it. So what makes you you're the guy who was snitching on Philip Turner in court, if I remember correctly, or who was like, I don't remember what Pigman Jojo had a video somewhere talking about how you basically rolled over on Turner in court. You're not, I don't know what metric you think you were the most effective auditor at. Maybe you had the most subscribers or the most views or whatever. But this is crazy. 184,000 subscribers and 6,000 views. I guess it's only been a day and a half. But that doesn't seem like it. That doesn't seem like you have a very active audience as far as like how many subscribers versus how many views you get. Let's actually take a look. Let's go down to an actual 36,000 from a year ago with a clickbait, oh my God, watch this quick before it's removed by YouTube. On a short video. 10,000 on a year ago on a 13-minute video. 23,000 on a 41-minute video. On 184,000 subscribers. Let's go to channels. There's another, what's this other one called? Like News Now Community or something? I'm not subscribed to it, so I don't know.
Not me. You guys. When that mess happened in El Paso where the FBI agents attacked me, do you guys know that those two senior FBI agents were both made to retire? And...
Both made to retire. First of all, citation needed. Second of all, were they going to retire anyway? Was there any disciplinary action? Can you show us the records of that, or is that on a thumb drive that you've given to your attorney? Did you know? Where was your lawsuit against them, Earl? Why didn't you file your little 1983 lawsuit against those FBI agents? Well, technically you can't because they're federal agents. Why didn't you file a Bivens suit or Federal Tort Claims Act suit against those FBI agents. Oh, you didn't, did you? But yeah, you got them disciplined, right? Right, Earl. Right.
The entire FBI got a new phone system because of you guys calling.
Right. Oh, citation needed. They got a new phone system because of you guys. Or they got a new phone system because they have to upgrade it every once in a while. There's something going on right now with the whole January 6th thing where the Attorney General is accusing the Secret Service of hiding evidence or something like that. And the Secret Service is like, we were migrating to a new phone system during this time. So just, we're ignoring the January 6th stuff. We could just use that bit as evidence that yes, in fact, government agencies do upgrade their phone systems from time to time. And the federal or the FBI thing was how many years ago, Earl? Maybe it was just time, but no. It's because of you guys. Earl tried to do a call flood on me at one of the law offices I work for, and it was like one day, and there were probably like maybe 20 people who called. Some people called multiple times, but it was not that bad. It was not that bad. It was a little irritating, but it wasn't that bad. Mainly because the head attorney of the law firm that I worked for didn't really know how to handle a call flood, and boy, he wanted to sue everybody. I'm like, dude, they got no money.
There's so much more. It's absolutely insane the level these people have gone to. I mean, Shell paid the Deer Park police bribes to target me.
Oh, citation needed, evidence needed. We're just going to accept your word that Shell cares so much about Earl that they have to pay the police bribes to have Earl's daughter allege that Earl molested her. And then the other two daughters also, I guess, must have bribes to allege that Earl molested them too. And, just like, it all makes sense, right? It's because of Shell. Oh, and there are CPS records, apparently, that relate back to this alleged molestation, back to like 1995 or something when it happened. So literally decades before Earl became a First Amendment auditor, literally decades before he was on anybody at Deer Park Refinery's radar, Deer Park was already paying off Earl's family to fabricate claims about him. It totally makes sense to me.
Bribes to target me. Hold on a second here. Let me fix something. There, took care of it. So that should tell you something right there. But regardless.
It does tell me something. It tells me you're lying.
Regardless of all that, I hope you guys, the district attorney is responsible for this. And
now it's the district attorney. So wait a minute. It was Deer Park. It wasn't his daughters, I guess. He hasn't blamed his daughters for any of this, even though his daughters are the ones making the allegations. It's Deer Park. But wait, it's not them. It's the DA. It's the same DA who wanted to dismiss the case, but Earl wouldn't let him. But she's responsible for this. Let's hear how she's responsible for this when just 2 seconds ago Deer Park was responsible for this.
She's got to be held accountable. And the way we hold her accountable is you vote. And I know I have a lot of subscribers here in the Houston area and Harris County area. And
you have a lot of subscribers in the area? Well, maybe, but they don't appear to be watching your videos there, buddy.
We're going to have to do something. This district attorney's got to go. She has this anti-man agenda, anti-father.
It's an anti-man agenda, anti-father agenda. It couldn't have anything to do with the fact that your daughters are accusing you of molesting them. It's just she's anti-father.
Agenda. She's a lesbian, and I don't even care about that. But when you have...
And she's a lesbian. I don't even care about that. Then why'd you mention it? Like, why'd you mention it? You mentioned it for a reason. Why? She's anti-man. She's a lesbian. I don't really care about that. Come on, dude. Who are you kidding?
You're in that position of power, and you start attacking fathers, and you start attacking men, and
attacking fathers, attacking men, or prosecuting men who have been alleged to molest their daughters by their daughters. crazy.
using that position, you got to go. It's that simple. So what I'm going to ask you guys to do, hey, Rusty, you can find Harris County District Attorney's Office, HCDAO, or, that's funny.
He was originally saying vote. Now what's he doing? Now HCDAO? Huh.
Harris County District Attorney's Office, or Harris County District Attorney Kim Ogg, K-I-M-O-G-G, Kim Ogg. You can find her on Twitter. You can find her on Facebook. You need to go let her know. If people tell me, well, the district attorney doesn't know anything about your case, well, it's time that she knows. I believe she knows, because this has been a...
Call flood the district attorney's office. Yeah, good luck on that, son. Good luck on that. Anyway, I've had enough of this. I've gotten through 10 minutes of video. I don't know how long it's been since I've started recording this, but it's been too long. This is all bullcrap and lies. Thanks for watching. Have a great day.